Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and today's question is one about teams. And the question that was asked is this. There's two brokers who always work together. They always work together whether they're representing a buyer or whether they're representing a seller. But, as circumstances would have it, it turns out that each member of the team is representing a different person, both of whom are interested in purchasing the same property. And the question came to me, is it possible in this team where these brokers work together all the time, is it lawful for one of them to represent one buyer and one of them to represent another buyer competing against each other? And the answer to the question is, yeah, of course. Because there is no such thing as a licensed team in Washington state. We don't even have a license law definition of what a team may be. A team is whatever the team says that it is, or perhaps what the team's designated broker says that the team is. But there's nothing to restrict two brokers who typically work together from representing buyers who are opposed to each other. So that's fine. When I first read the question, though, here's where I thought it was going to go. This, I think, is a more challenging question, but one that does come up from time to time. We have two brokers, team members, who are representing a seller. They've listed a property together. Some people might call it a co-listing arrangement, others would call it a team, but in any event, understand that both brokers are identified in paragraph 2 of the listing agreement as representing the seller. And now one of them has a buyer. And the question that I will sometimes get along these lines is it possible for these two brokers who are both appointed as a subagent of the firm to represent the seller, is it possible for one of them to peel off from representing the seller and represent the buyer exclusively? And the answer to that question is yes, if it's documented properly. Remember how we have representation in Washington state in the first place. When a listing agreement, for example, is signed, the seller is entering an agency agreement with whom? With the listing broker? Nope. With the listing firm. And within paragraph 2 of the listing agreement, Form 1A or Form 1B, the designated broker of the listing firm appoints one of its subagents, the broker identified in paragraph 2 of the listing agreement, as the firm's subagent representing the seller. That's how agency works in Washington state. So in our scenario where we have two brokers, both representing the seller, both named as subagents of the firm to represent the seller, if we want to peel one of those brokers off so that there's only now one broker representing the seller and another broker representing the buyer exclusively, what must happen is that the designated broker of the firm must withdraw the appointment of subagency to the one broker, leaving only the other broker as the subagent of the firm representing the seller. Does a designated broker have the right to do that without the seller's permission? Yes. Paragraph 2 of the listing agreement gives the designated broker that right. Would it be a good idea to do that without consulting the seller? Absolutely not. This absolutely should be something that happens in consultation with the seller. Seller, here's our scenario. Pam and Betty both are your agents right now, but Pam's son wants to buy the property. She'd like to represent her son exclusively. Would that work for you? Yes, that's fine. But wait a minute. Pam knows all of my confidential information. What about that? Agency law covers that for Pam. Pam is required anytime an agency relationship terminates, ends, is accomplished, is severed, whatever the outcome of it is, when an agency relationship is done, the broker is always required to maintain the confidences of that client learned during the term of the agency relationship. So if Pam and Betty are our two listing brokers and Pam is going to peel off so she can represent her son exclusively as the buyer of the seller's home, designated broker, you need to create a document that withdraws the appointment of Pam as a subagent of the firm representing the seller. You need to make sure that's communicated clearly to seller, and that seller, while seller doesn't have to agree to that, make sure that seller's okay with it. And then, in this case, Pam, while you go off and represent your son exclusively in the negotiations for seller's property, you have to maintain the confidences of seller that you learned during that agency relationship. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member. Do you like my new brick wall?